Good afternoon. My name is Jackie Boland, and I'm the Community Outreach Director for AARP Hawaii. And it's my pleasure to welcome you here today for Estate Planning, a seminar that's part of the 2021 Veterans Summit here in the state of Hawaii. Oh, pardon me, I'm having a slide issue. I just want to take a moment to thank the sponsors of the Veterans Summit, which is the Hawaii Veterans Foundation, the Hawaii Office of Veteran Services, and AARP Hawaii. We've all worked together to put together this series of webinars taking place over the last 4 weeks and the next 2 weeks. And speaking of upcoming events, I just want to mention that we have 2 sessions left in the Veterans Summit. On July 20th, we have an excellent panel to talk to people about behavioral health resources here in Hawaii. And July 27th, former POW Jessica Lynch will be talking about her experiences and her road to recovery. A few housekeeping details. We can see you, or actually we can't see you. You can see us. We can see your names only. We are recording this session, but you won't be on there. Also, we'll be using the chat function only for technical issues. We're not going to ask questions of the speaker using the chat. We're going to ask you to put those into the Q&A. So you just click on the Q&A tab, put your question in, and I'll be fielding those questions to our speaker later on at the end of her presentation. Additionally, we did have a request for closed captioning, so we have that on, or actually we don't have that on, we will have that on. If you want to turn it off, all you have to do is click on that live transcript CC button and just choose to close the transcript process or turn it off. Also, I just want to make a quick disclaimer. This workshop is really intended to be educational in nature, and it's not legal, investment, or tax advice. So if you do want that kind of thing, we strongly suggest that you make an appointment with an attorney. This is really to give you some broad brushstrokes so you know what you need to talk about with someone. Also, we're not endorsing a specific company, although we are fortunate to have an attorney from Sibling & Tucker here. We can't answer questions about their firm during this, and so it would be up to you to contact them after the webinar if you have specific questions about their firm. And with that, I do want to turn over the program to Michelle Skelly Hobas, who's an attorney with Sibling & Tucker. She's actually kind of amazing. I just found out today that she spent time in Calcutta working with Mother Teresa, and she spends a lot of time helping people preserve their financial legacies through estate planning and disability planning. So we're just so fortunate to have her here today. I think you'll really enjoy her. And with that, Michelle, you can just take it away.
All right, thank you so much. I'm really happy to be here, Jackie, and I'm happy to be presenting again to the AARP folks. I've done it in the past and it's very rewarding, and I'm happy to be here to help folks understand a little bit more about estate planning. We are an estate planning law firm and practice in this area. So I'm going to present to you folks a presentation today that hopefully will give you some information on estate planning that will help you get down the road of getting your estate planning done if you haven't already gotten started, or maybe give you some more information about it than you would already have. So this afternoon, we're gonna be giving this presentation. I wanna tell you a little bit about myself. I am an attorney at the law firm of Sibling & Tucker. I'm licensed to practice law here in the state of Hawaii, as well as the state of California. I've been practicing law since 1992. I'm a partner at the firm, and we practice primarily in this area of estate planning. I want to thank you folks for joining us this afternoon. I know many of you probably have other things you would rather be doing or could be doing, so I do really appreciate your time this afternoon and really hope that you get something out of it. We know, unfortunately, from this past year and a half or so that crises happen, unexpected things happen in our lives and in the lives of our loved ones. So it's really important to get your planning done in advance so that your family is prepared, and hopefully you're prepared if something unexpected happens in your life. And estate planning is certainly one of those things to get taken care of before it's too late. We know a lot of people procrastinate about this. They think about it, they know they need to get it done, but actually taking a step towards getting their planning done is sometimes too much of a big step for them. So hopefully by attending this presentation this afternoon, you're dedicated to getting yourself beyond the procrastination hurdle, out of your hammock and out of your easy chair, and to take care of things if you haven't already done so. We know sometimes that a lack of knowledge, or maybe sometimes too much information, is overwhelming to folks. So hopefully by attending this workshop, you're going to learn some things that will get you beyond this lack of knowledge or maybe too much information hurdle. Over the years, we've seen 5 major concerns from our clients that come to us for their estate planning. The 5 are: number 1, that they want their hard-earned assets to go to their loved ones without court involvement upon their passing. They want to avoid unnecessary taxes. They want to avoid going broke from long-term care expenses. They want to protect their family from predators and creditors after they're gone. And they want to pass down their wisdom, their life story, their history, their values to their loved ones. These are the things that we try to help our clients achieve. This is our agenda, our game plan for this afternoon. We're going to talk a bit about wills. We're going to talk about revocable living trusts. In the end, we'll talk about how to choose an attorney, and we'll have a question and answer session. That's kind of our game plan for this afternoon. Before we get into the nitty-gritty of it, though, we probably need to define that term estate. If we're going to be talking about estate planning, what does that really mean? Well, that word estate kind of covers everything you own: your house, your cars, your cash in the bank, stocks, bonds, mutual funds, IRAs, 401ks, life insurance policies, those things that you've really worked hard for to accumulate over your lifetime. That's all considered part of your estate. And all that stuff in your house, right? You look around, your furniture, jewelry, fishing poles, golf clubs, those things that you've collected over the years, the things that have been handed down from generation to generation that are now your kuleana, your responsibility to hand down. That's all considered part of your estate. And there's a couple of characters waiting in the wings to get their hands on at least some, if not all of it, right? Uncle Sam, the tax man, and the probate attorney. So we're going to talk this afternoon on how to try to avoid both of them. Those of you that already have your planning done know that you need to do your estate plan so that your hard-earned assets go to whom you want. If you don't write down who's going to take care of things for you and where your things are going to go, you know what? The court's going to get involved. Hopefully you have some friends, relatives, family members, loved ones, maybe a charity that you would want to receive your assets upon your passing. You really need to make sure that you're in control, because if you're not, the state of Hawaii is going to use the intestate succession rules and determine where your assets go. And it might end up with somebody you really didn't want to receive it, like that sister you don't really talk to anymore and her husband that you really can't stand, right? So you need to be in charge and make sure things are going to the people you want, and you want them to receive it when it's appropriate. If you have young children or young grandchildren, maybe you don't want them receiving a significant inheritance at age 18. Well, if the state is in control, that's what's going to happen. If you have a loved one that's on government assistance, like Medicaid or even some VA benefits, if they receive too much money from you, they could get kicked off that government assistance. That wouldn't always be the best case for them. And if you have loved ones that are involved in drugs and alcohol, probably not a great idea for a drug addict to receive a bunch of money to do whatever they want with, right? So we need to do special planning for those types of beneficiaries. And we want it handled by somebody we know and care about and cares about us and our family. Again, if you don't write down who's going to take care of things for you upon your death or incapacity, the state of Hawaii will be in control and appoint somebody to do that. Hopefully, you know somebody that is responsible, reliable, that you can trust to take care of your affairs upon your death or incapacity, rather than having a stranger who doesn't know your family at all take care of business for you. And we want to avoid unnecessary costs, right? We don't want our family to end up with less than we would really be able to leave them because so much has gone to court fees, attorney's fees, and taxes. We want our family to receive a majority of our assets, not a minority of them. We want to avoid the probate court system after we're gone, and we want to avoid it while we're alive as well. We want to avoid a living probate, a death probate, and of course, death taxes. These are the main reasons we do our estate planning, so that our hard-earned assets go to whom we want, when we want, handled by the person we want, and we stay out of the courthouse and we avoid unnecessary taxes. Now I'm going to walk you through the process of getting an estate plan done today using a case study with Bill and Mary Lee. They are retired, just like most of you would be. And they sat down one day, they added up everything they owned, their house, their cars, their cash in the bank, stocks, bonds, retirement accounts. Everything comes to about $700,000. Now you might be sitting there saying, hey, I'm not Bill and Mary. I'm single, I'm widowed, I'm divorced, I have more than that, I have less than that. It's okay. Whatever you have will apply to you today. I will point out the areas that are specific to married couples when we get there. So I want you to know a little bit more about Bill and Mary and their family. Bill and Mary have been married for a very long time. They have 2 children, 2 grown adult children. John is their oldest son, but didn't really turn out how mom and dad had hoped. In fact, he never finished school, doesn't really have a regular job, hasn't made the best decisions in his life, but he's still their son and they love him. Susan, on the other hand, is the younger one. She went off to college, got her degree. She's doing very well for herself, and she's married with a family. We're going to keep our eyes open for this rascal Harry because he's going to pop into the picture a little bit later. So I want you to remember that and keep your eyes open for him. We'll tell you a little bit more about him later. Now, Bill and Mary, they have options, right? We all have options when it comes to doing our estate plan. They could spend it all. I think that's my parents' option, but there's a small problem with that, right? If you're still here and you've spent all your money, that's a problem, meaning you won't have a place to live or food to eat. You also won't be able to leave any kind of legacy whatsoever to your family. You could die intestate. That means you die without a plan, and the state of Hawaii decides where your assets go. You could hold everything jointly. Sometimes people think that's the answer. The problem with that is that when both people on title to that property or the bank account are gone, then we've got a problem. You could transfer your things to your children while you're still alive. That's not a fabulous idea for most people because then you lose control over those assets. And believe it or not, the children that you thought were so well and so caring can sometimes turn around not to be the case once they have control over your assets. It also is not a great idea from a tax perspective. So you really have to be careful with that as part of a plan. You could have a simple will, you could have a bare bones trust, or a really comprehensive revocable living trust. Well, Bill and Mary, they decided on a simple will. They're going to go old school. They also made a bit of a to-do list. And on that to-do list is exercise, plan out their vacations, plan their retirement, create that will, and do some funeral planning. So what do you think they did first? Plan their vacation, of course, right? I'm sure that's what you all said. So they haven't been on a vacation in years, and they decide they're going to go on a trip to Europe. And Bill looks down and he says, wow, I want to look really good on that beach in France. So I better start exercising. Unfortunately, he doesn't talk to a doctor before he goes out for his first really brisk jog, and he has a heart attack. Thankfully, he lives in a good neighborhood. Someone calls 911. They get him to the hospital and he's recovering. He looks up at Mary and he says, wow, I think we should get to that will thing sooner than later. And she says, you're right. I'll call the real estate attorney that helped us buy our house 30 years ago and see if he can help us. So they call up the real estate attorney, and the real estate attorney says, Mary, I'm getting ready to retire myself, and I don't really do that kind of law, but tell me what you have in mind. She said, well, if I die first, everything goes to Bill. If Bill dies first, everything comes to me. When we're both gone, it goes to the kids equally. And he said, that sounds pretty simple. I think I can throw something together. So he puts together a very simple will for them. They go down, they sign it. They think everything's in order. Bill starts exercising again. And unfortunately, this time he has a major stroke. And we know people that have had strokes. And a lot of times you're affected on one side of your body. Well, Bill's affected on the right side, which means he can't speak effectively. He can't sign his name. He really can't manage his own affairs. So who's going to manage his affairs for him? He's disabled, right? So he can't sign any new paperwork to give anybody the authority to manage his affairs. I bet you're saying Mary, right? Just because she's his spouse doesn't mean she has the legal authority to manage his affairs. She can't go down to the bank and start writing checks out of his own individual bank account. She cannot call up the IRA people and tell them what to do with his IRA. So guess what? She goes down to the probate court. This is this family's first trip to the probate court. And they're going to go through what we call a conservatorship or guardianship proceeding. That's the legal process by which you get the authority to manage someone's affairs that can't manage on their own. It's not fun. It can be very expensive and very time consuming. The court is in control. They could look at Mary and decide she's not the right person to manage Bill's affairs. They could do a court-appointed guardian instead. There's going to be court fees, attorney's fees, accounting fees, because Mary has to do an accounting of everything she's done with Bill's affairs. She might have to bring him into court to, in fact, prove that he's incompetent or incapacitated. Not fun at all, and it costs about $10,000 for one of these proceedings. But they get through it, and then Bill passes away a few years later. So remember that simple will that they had that said if Bill dies first, everything goes to Mary? Do you think it happens quickly and cheaply? Not here, not in the state of Hawaii. They're going to have to go to the probate court again. This time they're going to go through what we call a death probate. Death probate is the process by which we transfer title to assets when someone passes away. It's also the process of which we pay off creditors when someone has passed away and is going to go through the probate court system. The whole idea is that we get things transferred to Mary, right? Because that's what the will says to do. But the judge has to look at the will, make sure it was done properly, and then assign somebody to be the personal representative and carry out the will's wishes. So we have to resolve disputes, pay off creditors, inventory and appraise the assets, and then finally distribute the assets to the beneficiary named in the will. It's very expensive. There's court fees, publication and bond fees, executor fees, attorney's fees. And who do you think gets paid first? The attorneys, of course. And the probate fees come off the top as well. In the state of Hawaii, we have a percentage of the estate standard now. It used to be called a reasonable compensation standard, but now it's a percentage of the estate standard like California has always had. So let's say we have a gross estate, meaning the total value of the estate going through probate is $600,000, the primary asset being a house. But there's a $200,000 mortgage on the property. That means the bank has to get paid off. So really the net equity is $400,000. At what level do you think the attorney's fees are calculated? The gross, I'm sure you're saying. So that means the attorneys are getting the fees for a $600,000 estate when the family really only has $400,000. And this is a national average of 2 to 3%. In the state of Hawaii, we're falling right in that same wheelhouse. Honestly, in the state of Hawaii, it's not unusual to have $1 million estate with the value of our real estate. So 3% of that is $30,000. Not a small chunk of change. And it doesn't happen quickly, especially now during COVID times with backlogs in the court systems. You're really lucky if you get through in 9 to 24 months. I've had clients tell me it took several years to get through the probate process. And it's open to the public, right? You see those public notices in the newspaper of estates going through the probate process. Believe it or not, there's scammers that see those notices as well. And they can show up to court and pretend that they're a long lost relative or that the person who passed owes them money. And even though it might not be a valid claim, the courts and the lawyers have to deal with it, which means more time and more money. If you own property in another state, even if it's vacant land or a timeshare, you're going to end up in probate in that state as well. So if you think probate's a hassle in your home state, just wait till you have to go through it in another state and pay a whole nother set of attorney's fees, court fees, and all those other hassles that go along with a probate proceeding. The disadvantage of probate, as you can see, are that it's expensive, it's time consuming, it's open to the public, and your family might be involved in multiple probates if you have assets in other states. The other thing that's really humbug when we pass is the idea of taxes, death taxes. The state of Hawaii has what we call a state estate tax, and the federal government has the federal estate tax as well. These laws have changed dramatically over the years. You can see from this chart that back in the 1990s and the early 2000s, you could pass about $750,000 estate tax free. Well, that has gone up dramatically. And currently, as we sit here today, each one of us can pass 11.7 million estate tax free for the federal government. That likely will change. In fact, it's supposed to change in 2025, if not before. We expect it to change before then. If you happen to have over that amount, the tax rate is 40% of anything over that amount. The state of Hawaii has a different structure. Currently, you can pass 5.49 million estate tax free upon your passing. If you have more than that, it's taxed at a rate of about 20%. These laws also could change. In fact, there was a bill introduced in the legislature this past session that would have changed this estate tax law. We keep our eyes on those laws and help our clients navigate those changes. But currently, as we sit here today, each one of us can pass 5.49 million estate tax free for the state of Hawaii. This is where things are a little bit different for a married couple. If you are married, you can pass an unlimited amount to your spouse, estate tax free. It's called the unlimited marital deduction. So if you happen to have more than that 11.7 million and you're married, you could pass the whole thing to your spouse upon your passing. But you have to be a little bit careful because then upon their death, there very likely would be an estate or death tax. Also, if you have a non-US citizen spouse, you have to be a little bit careful here because the federal government doesn't allow this unlimited marital deduction for a non-US citizen. You can imagine why, right? If my husband is a Japanese citizen, I leave him that 12 million that I don't have, and he goes back to Japan with it and dies in Japan, the federal government in the United States loses the ability to tax that money. So if you've got a non-US citizen spouse, we need to do special drafting in your estate plan to account for that. Now, those of you that are like me are probably sitting there saying, I don't have to worry about the estate tax, so maybe I don't need to do my estate planning. Well, we still need to do our estate plan so that our hard-earned assets go to whom we want, when we want, handled by the person we want, and we of course want to stay out of the courthouse. So even though we are not multi-millionaires, we still need to get our estate plan in order. So back to our story. There's Mary. She's been through probate twice now, a living probate for Bill when he was incapacitated due to his massive stroke, and a death probate after he died. She looks kind of relieved, I think, to be through the whole process. She ends up with the estate, the $700,000 in her name. A lot of us worry, what if we're the first to go? What's going to happen to our spouse? Well, the statistics tell us that our spouse will live an average of 7 years if we are the first to die. Just because your spouse died 6 years ago, that doesn't mean this is your year to go. It's an average. We're going to let Mary live for 10 more years. And we're going to say that she invested her money wisely. And over a 10-year period, it doubled. So by the end of her life, she has 1.4 million. Now, we also worry about other things for our spouses if we're the first to go. What if they get remarried? What if they fall prey to lawsuits or scams? Well, this is where I want to talk about that rascal Harry. Remember Harry that we introduced earlier? Let me tell you about him. Harry lives down the street from Bill and Mary and was widowed many, many years ago. But he always had his eyes on Mary. And once Bill passed away, he really has his eyes on Mary. He's over there at her house, helping with yard work, helping fix light bulbs, over for coffee in the morning and dinner in the evening. So what could happen? Could Mary get married to Harry and give everything to him? Sure. What if Harry has kids from his first marriage that are saying, hey, Dad, get us some money from Mary. We know she got that life insurance from Bill's life insurance. Get us some money. Could she give money to Harry's kids? Sure. We hope none of that happens, but it's certainly possible. And then Mary ends up with Alzheimer's. And a lot of us know loved ones that have been affected by this disease. And if you have full-blown Alzheimer's, you're not managing your own affairs. So who's going to manage Mary's affairs for her? Any thoughts? I'm sure there's some thoughts running through your mind, but does anybody have the legal authority to do so? No. So guess what? We're going to go down to the probate court again. This is our third trip to the probate court, and this time we're going through a living probate or a guardianship proceeding for Mary because nobody has the legal authority to manage her affairs. So what if Susan and John show up? Who do you think the court should appoint? You're probably saying Susan because you know the story. But what if John shaves, gets a fancy suit, puts on that suit, gets a haircut and shows up in court? He's the eldest. It's possible the court could appoint him. And what if Harry shows up and he wants to manage Mary's affairs? Now we've got a real fight on our hands, right? Susan, John, Harry all want to manage Mary's affairs, and they all get lawyers, right? Susan gets a lawyer, John gets a lawyer, Mary has a lawyer, Harry has a lawyer, the court has their own lawyer. It's a whole mess of lawyers, lots of money, lots of time, lots of expense. We're going to hope that they see through it and appoint Susan, but they might have to bring Mary into court to prove that she's incompetent or incapacitated. And Mary is going to be suffering through all of that. It's going to take several months. And in the meantime, nobody has the authority to manage her affairs. We're going to assume that they named Susan. She manages things for her mom. She has to do an accounting to the court every year. And then Mary passes away. So what's going to happen now? Remember that simple will that they had? Well, we're going to take it down to probate court because everything was in Mary's name, but she didn't do anything about it. It ended up in her name only when she died. So we have to go through the death probate process to transfer title to the kids upon her passing. We take that will and we go down to probate court. There's, again, court fees, publication and bond fees, executor fees, attorney's fees. A very conservative estimate for this size of an estate is going to be in that $30,000 range, even if they held everything jointly. So that's why I want to be clear that joint tenancy isn't always the answer, because eventually you're both going to be gone. So that's not really a good answer. And a simple will is not a great answer either, because it means we're going to go to probate court if you have more than 100,000 and we don't have beneficiaries named. Taxes. Do we have a tax problem for this family? Probably not, right? Because remember, in the state of Hawaii, we can pass 5.49 million estate tax free, and the federal government is 11.7 million. So this family does not have an estate tax problem, but they've spent over $40,000 in 4 trips to the probate court. That seems like a problem to me. If there was money owed for estate tax, the federal government wants it within 9 months of the person's death. And if you're stuck in a probate proceeding and you don't have access to the funds, that becomes a real problem. All right, we've gotten through probate court 4 times now, and we are now distributing things to the kids. 1.4 million was the size of the estate when Mary passed away. 700,000 for John and 700,000 for Susan, because it's going to go to their kids in equal shares. Do we really think the kids are ready for it? A lot of people worry, what's going to happen to my kids? What if they get divorced? What if they have opportunistic friends? What if they get involved in a lawsuit? Well, Susan's the good daughter, right? But she's married to this guy, Jason, who's pretty lazy. Not really the best son-in-law in the world. What if he just waits until Susan receives her inheritance, convinces her to put it in a joint bank account, and then files for divorce a year later? What happens? He can walk out with half of that money. Probably not what mom and dad would have had in mind. And John, what might he do with his 700,000? Probably have a good time. Maybe he has a big party, gets a fancy car, gets in a drunken driving accident and injures somebody, or God forbid, kills somebody. That money would be gone in an instant. What if he owes back taxes? The money could be gone in taxes or to creditors. There's got to be a better alternative for this family. Rather than 4 trips to the probate court, possible remarriage of the spouse when the first one dies, and money going out the door in a divorce of a child, and to lawsuits for another child. So we really hope that there's a better alternative. And we think of that alternative as a revocable living trust. So rather than having those simple wills, it might have been better for Bill and Mary to have a revocable living trust. I'm going to walk you through how a trust works. Those of you that already have a trust, this will be a bit of a review. We really think of a trust as kind of like a treasure chest. It's where you're going to hold title to your assets. You might own things in your name only or joint with somebody else, but when you have a trust, the idea is that you're going to transfer your assets into the trust. So we're going to wave our magic wand and bring Bill and Mary back to life and give them a second chance at this whole estate planning thing. This time, they're going to set up a revocable living trust instead of having simple wills. The first step when you set up the trust is to actually put your stuff in the trust. We call it funding the trust. Very important step to take. So their house is going to go in there, their bank accounts are going to go in there. And there's 3 different positions or titles that a person would wear when they have a trust: the trustors, the trustees, and the beneficiaries. So this is kind of our vocabulary lesson for this afternoon. The trustors are the people that own the assets in the trust. They set up the trust and they put their stuff in there. The trustees are the people that manage the assets in the trust: buy, sell, trade, take things in and out. Make sure that it's managed properly. The beneficiaries are the people that get to spend or use the assets in the trust. So we're going to put Bill and Mary in all 3 positions. They're going to be the trustors, the trustees, and the beneficiaries. They're going to create the trust, they're going to be managing it, and they're going to be the beneficiaries. They're the co-trustors because they own the assets together. They're setting up the trust together, and they're putting their jointly held assets in the trust. They're the co-trustees, the co-managers. If one of them can't take care of things, then the other one will. They've named Susan as their successor trustee, right? Because she is the responsible one. They get to be in control. They get to say who would manage their affairs if they're unable to, and they name Susan. And they're both the beneficiaries, right? They get to spend or use the assets that are in the trust. So it's really business as usual. Those of you that already have a revocable trust know it's not a big deal, right? You might notice when you get your bank statement that there's a TR, meaning trust, or a TEE, meaning trustee, behind your name. Otherwise, you can take your money in and out of the accounts, no problem. You don't file a different tax return. You file your returns just the way you always have. You still get your homeowner's exemption off your property tax, even though you put your house in your trust. So it's really not a big deal. It's pretty much invisible for legal and financial purposes, but it's important. It's a standby device for your family in case you become incompetent or incapacitated, or once you pass away, so that they know what to do. They know who's going to be taking care of business, and they follow your instructions. So there's really seamless transition and not a lot of hassle with the courthouse. Now, for a married couple like Bill and Mary, there's 3 different stages or phases to a trust. If you set up a joint trust, there's going to be the first phase when you're both alive and well and you're putting your assets in the trust. There might be some things that you keep out, like a life insurance policy, an IRA, an annuity. We talk to our clients about what stays in and what stays out of a trust. The second phase is when the first person has passed. So in this case, that would be Bill. And then the final stage is when we have the distribution to the beneficiaries. So that's kind of generally speaking how a married joint trust would work for a married couple. So they set up this trust, and then Bill has that stroke. Remember, he had that major stroke. Remember last time they had to go to probate court and get Mary appointed as the guardian or the conservator for Bill so that she could manage his affairs? Do we have to do that this time? No, because everything's in the trust and Mary is the co-trustee, the co-manager. We also probably gave her a nice strong power of attorney so she could help manage Bill's affairs that are outside of the trust. So we've avoided our first trip to the probate court and all the fees and hassles associated with a guardianship or conservatorship proceeding. We don't have to haul Bill into court. The court does not have any kind of involvement. Mary just keeps managing things, no problem. So we've saved this family already 1 trip to the probate court and over about $10,000 in fees just by having a revocable living trust in place. And then Bill passes away. So remember last time we had to go to probate court to get things transferred out of his name because death probate is the process by which we transfer title to assets. Do we have to do that this time? No, because they already transferred title to their trust. So we don't have to change title to the assets. They already did it while they were alive. Everything's in the trust, and the trust has instructions as to what's supposed to happen now that the first person has passed away. Very simple, not a lot of hassle. Mary just keeps managing things. So we've avoided our second trip to the probate court and all the hassles and fees associated with that. No court fees, no publication and bond fees, no executor fees, a much better result than last time. Now, this is where things can get a little bit complicated if you're a married couple and you have a trust that is designed to split when the first person passes. Sometimes we call this an AB split or a survivor's trust, family trust split. This is what it would look like. Remember that $700,000? There's $350,000 now going into the survivor's trust. That's Mary's share, and $350,000 going into that B trust, the family trust. That's considered Bill's share. Now Mary's still in charge, right? She's managing assets. She's the manager. She's investing it wisely, and it grows over that 10-year period of time. So in the end, we end up with $700,000 in the A trust, $700,000 in the B trust. Mary's entitled to all the income that flows off the assets that are in that B trust, but she can only touch the principal for her reasonable needs. We call it health, maintenance, support, and education. That B trust is irrevocable, meaning Mary has limited access to it, and she has to file a separate tax return for it also each year. So how does this structure help us? Well, for this family, it was probably a good idea because of that rascal Harry. Can Harry get to the stuff that's in that B trust? No, because it's for Mary's reasonable needs, not to give away to Harry or his kids. So we've just protected at least half of the assets for Bill, from Bill's, to go down to his kids. No remarriage issues here. However, Mary can do whatever she wants with that money that's in the survivor's trust, that half that she has complete control over. Then Mary ends up with Alzheimer's. Remember last time we went to a guardianship proceeding and Susan, John, Harry all fought over who was going to manage her affairs? Do we have to do that this time? No. So we've avoided our third trip to the probate court and all the fighting and expense of a protracted, contested guardianship proceeding. Susan's in charge because they named her as their successor trustee. She has instructions in the trust as to what she's supposed to do with the assets, which is basically manage them for her mother's benefit. She doesn't become the owner, she's just a manager. So we've avoided now, again, our third trip to the probate court and about $10,000 in fees, probably a lot more because they had fought prior. Those contested guardianship proceedings can get very, very expensive. So this time we avoided that. And then Mary passes away. So remember last time we went through a probate proceeding to get things transferred out of her name to the kids? We took the will down to probate court. The judge looked at it, oversaw everything. Do we have to do that this time? No. Why not? Because they transferred everything into the trust, right? Remember, death probate is the process by which we transfer title when someone passes. Because they had already transferred title to their trust, they don't have to go to probate court. So now we've avoided the fourth trip to the probate court, all the fees, hassles associated with that. So we saved this family over $30,000 just in this event by not having to go to probate court. So remember that chart, how the trust split when the first person died and we had that A-B split? Well, when the second one dies, we bring everything back down together and we have it distributed to the beneficiaries. Susan's in charge, right? She's the successor trustee. She's going to oversee, make sure all the bills get paid, the final tax returns get filed, and then she's going to oversee the distribution of the rest to her and her brother, John. Now, if you're single, you're just going to avoid that middle section, right? Obviously, the trust isn't going to split, but you can pass the same amount, estate tax-free, $5.49 million for Hawaii and $11.7 million for the federal government. Now, mom and dad probably had a clue that Jason wasn't the best son-in-law in the world. So maybe they put some protective language in their trust for Susan. We call it divorce protection at this firm. What that means is when Susan receives her inheritance, it would have a protective shield or a protective layer on it. If she were to get divorced down the road, her spouse wouldn't be able to get to it. So it prevents Jason from getting access to Susan's inheritance. And we probably could have done a whole lot to help John. We could have put a creditor protection provision in there that says if he got sued or he owes people money, it's not considered his asset and therefore it's protected. Somebody else would be managing it for him, doling it out to him for his reasonable needs, but at least it would save the money from creditors and predators. What if John really needed some incentive to get his life together? Maybe mom and dad felt that they want to put language in the trust that says he has to be drug and alcohol free, or he has to go back to school and get his degree, or he has to work in the family business. There's all kinds of incentives that families can put in a trust for their children after they're gone. But what if John is actually a disabled person? Maybe he has a disability. He's on government assistance of sorts. If he receives more than $2,000 and he's on a government program like Medicaid, he's going to get kicked off that government assistance. We could put his inheritance in what we call a special needs provision for him, which would allow him to benefit from the inheritance, but not get kicked off his government assistance. So this family did much better with a trust than those simple wills, right? We saved 4 trips to the probate court and over $40,000, as well as protecting their children from divorce, from remarriage for the spouse, and from creditors and predators and lawsuits for John. Now, not every trust and never every estate plan is created equally. We've seen a lot of documents come through our doors over the years. It's extremely important that you get these estate planning documents done well and get them done where they are tailored to your family. Because if you don't, your family's going to have a lot more problem than if you would have not done anything at all. So be very careful. Make sure you're going to a qualified estate planning attorney. Sometimes people will go to a probate attorney to get a trust done. I don't know if that makes a lot of sense because the probate attorney is used to going to court with wills, not necessarily in the business of avoiding probate. So you have to be very careful about that. The advantage of having a proper revocable living trust in place is that your hard-earned assets will go to whom you want, when you want, handled by the person you want, and your family is going to stay out of the courthouse. They're going to avoid a living probate, a death probate, and those death taxes. Now, there are many pieces to the estate planning puzzle. We talked a lot about trusts just now, but there's other pieces to an estate planning puzzle that are very important. The living trust will probably be the biggest piece of the puzzle, but you also need a will. When you have a trust, though, your will is what we call a pour-over will. It scoops up anything that you happen to leave out of the trust and pours it into the trust. That's why we call it a pour-over will. You also need a power of attorney. In fact, every responsible adult, anybody over 18, should have a power of attorney in place. We generally call it a general durable power of attorney. It's to help take care of legal and financial matters that are not part of our trust. So think of a trust as like a treasure chest. Again, you're going to put your house in there, probably some bank accounts, but your retirement accounts are not going to be going in there. If you break your arm, you have a stroke, and you can't take care of those things that are outside of your trust, that's when the power of attorney comes into play. This names somebody who could take care of those things for you while you're alive, but unable to do so. This law changed in 2014. Hawaii passed the Uniform Power of Attorney Act. So I would suggest anybody who had their power of attorney done before 2014 should get it updated, or at least speak with your estate planning attorney to see if it needs to be updated. Everybody also needs an advanced healthcare directive. We saw this come into play very, very much so in this past year and a half, with people ending up with COVID and in the hospital without a healthcare directive. And because your family can't get in there to help you make decisions or speak on your behalf, the doctors were kind of stuck. Make sure you have an advanced healthcare directive in place. This used to be called a living will or healthcare power of attorney. In 1999, Hawaii married those two into what's called an advanced directive. So make sure you have an updated healthcare directive on file at your doctor's office, and make sure your family knows where it is. It allows you to name somebody who would speak to the doctors if you're unable to, and allows you to make your choices about what you want or don't want in regards to your end of life care. The other form we all need is a HIPAA form. HIPAA stands for the Health Insurance Portability and Accountability Act. That's a privacy law that says doctors, nurses, hospitals, and insurance companies cannot release any information about you without your authority. So it's really important that everybody, again, even our adult children, need to sign one of these so that your loved ones can find out information. Otherwise, the doctors and nurses aren't supposed to release any information to anybody. The most complete estate plan that we would normally prepare for people includes a revocable living trust, especially if you own real estate, a pour-over will, a power of attorney, healthcare documents, and possibly a property agreement. That's for married couples that have property in a community property state or have lived in a community property state, such as California, Arizona, Nevada, Idaho, Texas, Washington. We would evaluate that situation for our clients to see if they needed one of those. What we do at this firm is we organize the estate planning documents for our clients in a binder that looks about like the one that's behind me. It's really important that you stay organized for your family members. A lot of times people come to see us and they just throw a bunch of paper on the table and they have no idea what any of it means. We organize everything in a binder. We tab the binder for easy reference. We put an explanation page before each document so our clients know what that document is. If they're forgetting what's a pour over will, there's an explanation page in there. We put a location list, which is a list of important documents that most folks have in their possession. And we create a chart so our clients can get organized and indicate where they're keeping their important documents. It's really important that your family knows where to find your stuff if something were to happen to you. There's a flow chart in our binders, the estate planning portfolio binder, that shows our clients how their trust works so they can have an overall visual of how things are going to go. We give them instructions on how to transfer their assets into the trust so they can make sure that it's properly funded, and we give them the tools to be able to do that. It's called the short form of the trust. I am also familiar with VA long-term care benefits, so I can help our veterans understand their long-term care benefits. There are two programs. One is called Aid and Attendance, and the other one is called Housebound Benefits. You veterans should know about these programs. If you have not heard about them, I highly recommend that you research them. You go up to the VA Center up at Tripler or wherever you're located and ask your VA representatives about these programs. They are designed for veterans that need help with long-term care. So if you are a veteran and you need help with care at home, getting back and forth to the bathroom, making meals, that kind of thing, you might be entitled to some financial assistance called Aid and Attendance or Housebound. There are restrictions on who can qualify for these benefits. Most of those restrictions have to do with financial resources. As you can imagine, they're complicated. So it's really important that you meet with somebody up at the VA before it's too late and understand what these benefits are and whether or not you might qualify for them someday. We can also help our clients with the divorce protection, the creditor protection, special needs protection, setting up irrevocable trusts if that's necessary for a family. We are experienced in all of these areas. And as Buddha says, the trouble is you think you have time. We've heard this comment, sadly, more than once this past year and a half. Oh, uncle thought he had more time. Nobody thought he was going to get COVID. Really important that you get your act together, you get your documents in place before it's too late. We want you to get out of your hammock and off of your easy chair and make sure your things are in order. So hopefully the information you've received this afternoon has helped you understand some of the things that you can do to get your act together, to get your estate planning in order. We don't want you to look like this guy with your head in the sand and your okole in the air. We want your family to be able to take care of business for you if you're unable to, and we want things to go smoothly for your family upon your incapacity or your death. I'm going to open it up to question and answers now. So I think that I have some questions here that I'm going to read and do my best to answer. If you have a question, you can type it into the Q&A on your screen, and we will be able to answer those questions. Okay.
Michelle,
so,
would you like to stop sharing your slides and then
sure.
I'll field those questions to you if you like.
Okay.
Terrific. Thank you so much. So just a reminder, folks, if you have specific questions about Michelle's company, you'll need to contact them outside of the webinar. But Mary Kay is asking, can you please explain the difference between the revocable and irrevocable trust and the advantage or disadvantage for one versus the other?
Okay, great question. What we talked about this afternoon was really revocable living trust. So a revocable living trust is one that you have control over and you have access to. You can take money in and out. You can refinance a property that's in there. It's really your asset, and you can change it at any time you want as long as you're competent to do so. That's mostly what we would prepare for somebody. However, an irrevocable trust sometimes is used if you want to get assets out of your name. Let's say I'm a multimillionaire and I have an extra property that I don't need, and I want to get it out of my name from an estate tax perspective. I might put it into an irrevocable trust for the benefit of my child, my son. Maybe I don't want it transferred to his name because I'm not quite sure that he's capable of handling it. So maybe I put it in an irrevocable trust. I'm not saying we don't ever do irrevocable trust, but it's a pretty big deal because you understand once you put something into an irrevocable trust, you don't own it anymore. So it's really a vehicle that's used to get things out of your name, but allow you to put down how you would want it to be used and who can use it. So for most people, their estate plan would be centered around a revocable living trust, not necessarily an irrevocable trust. However, after we pass away, our revocable trust does become irrevocable, meaning it can't be changed after we're gone.
Thank you. This person asks, if there's no spouse, no children, no nieces or nephews, only one sibling, no responsible friends or children, how do you determine who the successor should be after your sibling?
This is a really tough issue, and it's a common one, unfortunately. If you can't think of a responsible adult that is hopefully somewhat younger than you to manage your affairs for you upon your incapacity or once you've gone, your next option really would be to consider a professional trustee, such as a bank. The main banks in town, First Hawaiian Bank, Central Pacific Bank, and Bank of Hawaii, all have trust departments. They might be a good fit to be named as a successor trustee. There are a few private trustee options as well. One is called Estate Administrative Services. The other one is called Maximum Legal Services. I think there's a couple more. So there are those options as well. They certainly come with advantages and disadvantages. The advantages are those are professional organizations. They're probably going to do a very good job. The disadvantages, they're going to charge for their services. So if you are in that position where you can't think of a responsible adult in your life to help you, you might be needing to go talk with a professional trustee service, such as one of the banks, to fill that role.
And just to follow up on that, so if you're in that situation, is the reason that you'd be looking for someone to fill that role in the event of incapacity? Is that why you would want to have at least something or somebody named? Because otherwise, couldn't you just leave everything to the Humane Society? I mean, like what is the thinking behind that?
Okay, so yes, certainly while we're if we become incapacitated, somebody has to manage our affairs, and the Humane Society is not going to do that for us. Also, unless we're a dog or a cat, maybe, upon our passing, even if we've named the Humane Society as a beneficiary, let's say on our bank account or something, or in our will, somebody still has to pay our last medical expenses, file our final tax returns, oversee the distribution of our last remains. So there are certain things that have to be done when someone passes away that a charity probably is not going to be taking care of for you. So you need a responsible party to take care of business for you upon your death or incapacity.
Thank you. And so Terry is asking, could she and her mother form a trust together, or is it only for married couples?
Sure. Anybody can form a trust together if it makes sense. And on occasion, we do that. So for instance, I have a family right now where the family home was left to the 3 siblings, and they still own it together, and they have hui together, they've gotten together, and they're going to create a trust together. We call it a family trust or a legacy trust together, and they're going to put the house in there, and they're all agreed on where it's going to end up in the end. So you don't necessarily have to be married to set up a joint trust together. Really, the key is that you own assets together that you want to control where they're going to go.
Okay, that's very helpful. Thank you. And I know that various firms have various fees, but Diane is just wondering if you were using Bill and Mary's example, is there a ballpark cost for a revocable living trust?
Yeah, every family is different, so it's hard to say exactly what somebody's fees would be. It just depends, but I would say for Bill and Mary, if we were creating an estate plan for them, we would create a married joint trust, pour over wills for each of them, powers of attorney for each of them, healthcare directives, the HIPAA information release forms, as well as short forms for the banks. We also include in our fees free meetings, free phone calls. There's never a charge for communication at our firm. So our fees might be a little bit different than other law firms who charge differently, have a different format. But I would say ballpark for that family would be close to $5,000 once we get the property transferred into the trust as well.
Thank you. And so Anne is just wondering, can the federal or state government override a trust? She's asking who came up with it. And I think that the root of that, although I could be wrong, is this something that legislatively could no longer be an option for people? Could it change that this was no longer something people could do?
Interesting. I believe the history of it stems back to the late 60s, early 70s, when people got really frustrated with going through the court system all the time with wills. So this was developed by lawyers and the legislature to allow for this to happen in a private way where we don't have to go and have court oversight or involvement. Whether or not it would ever go away, I can't imagine that, but who knows? Nobody can predict the future. I really can't imagine that that would be anything that could happen. Sometimes people worry about, can someone contest my trust or challenge it? That's really what would be more likely to happen than the government saying that you can't have a trust. It would be someone challenging it because maybe you weren't competent when you were signing it, or you were under undue influence or something like that. But I don't really foresee the legislature passing laws to get rid of trusts in the future.
Okay, thank you. Kathleen's asking, she says her mom lost everything when she went into a long-term care in a nursing home. How does one protect against losing assets in a case like this? My husband is a vet, and I have heard there's a vet's asset protection plan. Do you have any information on this?
Okay, I don't know your mother's situation in particular, but yes, nursing home care is very expensive. We give a presentation on Medicaid and VA benefits around this very issue every December. If you are concerned about this issue, it's very important that you meet with a qualified estate planning attorney that is familiar with Medicaid. That's Medicaid with a D, not Medicare with an R. Medicaid is a federal program that will help pay for long-term care costs if you can't afford it. And as I mentioned earlier, the VA has a program called Aid in Attendance and another one called Housebound that will also help pay for long-term care benefits. If you're concerned about this issue, I would highly recommend educating yourself on the benefits that are out there and also the qualification factors for Medicaid, which is available to anybody, not just a veteran. You can only have $2,000 or less in your name, generally speaking, in order to qualify. Your house typically in Hawaii is not a problem, but if it's worth too much, it could be a problem. And for the VA, same thing. There's a cap on how much money you can have and still qualify for their government assistance. So it's really important just to get educated in advance and make sure you have proper documents in place, because there are things that we can do. For instance, I met with a family recently where a husband just died. They're really worried about their mom. It looks like she might need nursing home care in the future. So we're starting the process to get things out of her name because she's still competent and wanting to do it. But you have to have enough lead time for Medicaid. It's a 5-year look back period. And there's a 3-year look back period for the VA benefits. So you have to, again, start early, get organized and get educated about what benefits are out there and what you can and cannot do in order to prepare for them.
Thank you. And I would add, we did a great session on the Big Island a couple months ago when we learned that the Veterans Long-Term Care Facility over there has, it's a great resource for people who qualify. Some people don't pay anything. Some people pay on a sliding scale. So check the veterans specific long-term care facilities before going just anywhere.
Absolutely. Yeah, and there's one here on Oahu up at Tripler as well. But the one in Hilo is great. It's relatively new and a great facility. So definitely tap into those resources.
Awesome. We got 7 more questions here. And folks, I notice a few people are putting questions in the chat, but if you want them to go to Michelle, please put them in the Q&A because I can only look at one place at one time. So Dennis is asking, how do we determine what should be placed in a trust and what should be kept out?
Very excellent question. And this is super important, something that we work very diligently with our clients on. I tell my clients, think of 2 pots, the trust pot and an individual pot. So the trust pot is going to hold things such as your real estate, your checking, savings, stocks, bonds, mutual funds that are not part of your retirement account. And then the individual pot is going to hold your IRAs, your 401ks, life insurance policies, annuities, things that would be in your individual name. The key factor is you don't want a tax deferred type of asset going into a trust. So for instance, an IRA, a 401k, when you put money into those, you didn't pay the income tax yet. When the money comes out, you have to pay your income tax on your required minimum distributions. You don't want that type of asset being associated with the trust, because after you die and your trust becomes irrevocable, the income tax bracket for an irrevocable trust reaches a 40% tax bracket very quickly. So you really don't want your tax deferred assets being associated with a trust. Extremely important and very confusing for people. So something that you should discuss with your estate planner and your tax person, and maybe even your financial planning person as well.
Thank you. That's really interesting. So Leona is saying she and her spouse don't have kids. They have separate bank accounts that are in each of their individual names. Does that mean they should be doing separate trusts?
That's interesting. Sometimes couples do separate trusts. It really depends on if you're willing to share control and access to your assets. If you are, and you agree on where things are going to go when you're gone, you could probably set up a joint trust. But if you like maintaining your own separate control over your own separate assets, and you have ideas about where you would want yours to go, and he has ideas about where he would want his stuff to go, then maybe separate trusts make sense. This is a good example that not everybody's the same, right? Not every estate plan is going to look the same. So you really have to evaluate your own situation, look at what you have, where you want things to go, and decide how you want to structure your estate plan. Some couples have his, hers, and theirs. They might each have their own separate trust for their separately held assets and a joint trust for their jointly held assets.
And Marianne is asking, exactly how does divorce protection and or lawsuit and creditors protection read in a trust?
Okay. It really, we don't blatantly say divorce protection in the trust. It doesn't shout that out. It's just the way that it is structured. So basically, when you pass away, we create a little mini trust for each of your children. And the language of that little mini trust says that it's for your child's needs and use and not for anybody else's. So it really creates a shield over there. If your child is like John in our story, we probably are giving somebody else the role of trustee or the keys to his treasure chest, his little mini trust. Because if we let him have the keys to his own treasure chest and be in charge of it, it's going to water down the creditor and the asset protection. But if we have Susan, who's responsible, reliable, she makes good decisions, we could probably give her the keys to her own treasure chest and trust her to keep it protected. So again, everybody's different, every kid is different, every family's different. So we just have to adjust. But essentially, we create a little mini trust for that child upon your passing.
And I think this is along those lines. Dennis is asking, what about generations skipping trusts?
Okay, that was very popular back in the 1990s because it was a tool to help pass the estate tax down to the next generation. I still see it happening, but with less frequency. And some people might call it controlling from the grave. So a generation skipping trust basically says, look, child, I'm going to leave it for your use, but restricted use, meaning you can only touch it for your reasonable needs. And whatever's left in there upon your passing is going to go down to the next generation, i.e. my grandchildren, for example. So you basically skip a generation. You say to your children, you don't get full use of it. You can only touch it if you can prove that you need it, but it's really meant for the grandkids. And that means your trust carries on for your kids' whole lifetime. And some people like that idea. I'll tell you that most kids don't love it, but some are put up with it.
I was going to say, I'm sure I know who doesn't like it. So how do you determine, I don't know if you can answer this, but how do you determine how much to pay successors to carry out the trust?
That's easy, actually.
Oh, good.
The state of Hawaii has passed a law called the Trustee Compensation Act, essentially, where there's a structure to indicate what trustees are allowed to take as compensation for their time and energy administering the trust. They're allowed a certain percentage. It's around 1 to 1.5%. It depends on the size of the estate and the activities the trustee has to be involved with. So that's a very plain and simple structure to follow. Before that law was in place, we used what's called a reasonable compensation standard, and we would tell trustees kind of keep track of the hours you're spending and the type of work that you're doing. And then normally we would allow them to take compensation based upon their rate of compensation at work if they had a job. So there's different ways to approach it, but now the state of Hawaii has a very clear-cut trustee compensation law that we can follow.
Thank you. So we're coming on 3:15, and are you able to go to 3:30 on questions if we have that many, Michelle, or are you
Sure.
okay on time?
Yeah,
okay. Fine. All right, because I see some more coming in. Let's see. Kaz says, I understand that in a will, you should leave a minimal amount to each child. Is this correct?
This question, I think, has to do with preventing children from challenging your estate plan. I think that's where that's coming from. There's different schools of thought on this. You don't have to leave your kids a dime, frankly. You could leave it all to the Humane Society. You could leave it all to AARP. You can leave it all to whomever you want. Really, you don't have to leave your kids anything. However, if you're going to leave them out completely, I would suggest that you specifically state that in your estate plan, meaning you say, look, I acknowledge you. I know that you exist. I know you're my child, but with full knowledge and intent, I'm leaving you nothing. That's perfectly fine. You can do that as long as you're competent and you're not under undue influence when you're creating that document. Some people will say, oh, leave them $1, and then that shows that you acknowledge them. But you have to be careful because now they're a named beneficiary in your estate plan, and now they have rights as a beneficiary, which means they have rights to the documents and things like that. So I would be a little bit careful about that. I think different attorneys might have different philosophies on it. You want to just make sure, I always tell people, understand what you're doing, why you're doing it, and what the consequences are. If you really don't want to leave your kids anything, frankly, you don't have to.
Okay, thank you. June is just asking, can you, in a nutshell, say what the difference between an estate plan and a trust is?
Okay, well, estate plan is kind of like an umbrella, an overall umbrella of getting your things in order so that your loved ones receive it in the appropriate way upon your passing. A trust is a piece of an estate plan or a type of an estate plan. So under the umbrella of an estate plan, you might have a will, an irrevocable trust, beneficiary designation forms are part of estate planning. A trust is really a tool to achieve an estate plan.
Thank you. Anne is asking, how do you find professional trustees and know how honest they are? Is there
Yeah, we
prescription
talked
for
about
that?
that a little bit earlier.
Yeah.
I would say you're looking at talking to one of the banks. Again, the main banks in town, Central Pacific Bank, First Hawaiian, and Bank of Hawaii all have trust departments. They have a lot of oversight, meaning they are heavily regulated. So I would say they're probably honest people or doing good work. I really don't.
Do they have like FINRA, when a financial planner has a mark against them, you can look it up on FINRA's website and it'll tell you this person. Is there anything like that around trustees?
I don't think there necessarily is for professional trustees. And honestly, this state is kind of lacking in trust companies. We used to have private trust companies, but years ago, the banks co-opted most of them. So they kind of have a monopoly, so to speak, in this area. Okay. So I would say, they're professionals, they have oversight. I would think that I've never heard a problem, frankly, with the banks as trust officers.
Okay, so Anonymous would like to know, although I do think you answered this already once. He's saying, in the case of a married couple with no children, is it still advisable to create a revocable living trust? Maybe
not. It's really up to you. Again, you all have different options when it comes to doing your estate plan. I've had couples come to see me with no children, and they feel like, why should I be spending the money to set up this trust and do all of this? I'm just going to, have a simple will, let it go through probate court, and let my beneficiaries pay for it. I don't really care. So that's really up to you. You don't have to set up a trust. And especially if you don't own real estate, and if you have less than 100,000 in the bank, you probably don't even need a trust. But it's really up to you. Again, I tell people understand what you're doing, why you're doing it, what the consequences are. If you don't create a revocable living trust and you just have a simple will, that means your family's going to end up in probate court, and there's going to be significant fees associated with that. But some people don't care. They don't really care if their family has to go through probate court.
Thank you. And then Claire is saying her trust was done before 2014. What happens if she doesn't update it?
The trust isn't necessarily a problem after 2014. It's your power of attorney document. So the local banks can refuse to honor a power of attorney if it doesn't meet the Uniform Power of Attorney Act regulations that were passed here in 2014. So my suggestion is, if you had your documents done before 2014, if you did not put your stuff in your trust, meaning you have bank accounts that are in your individual name, and of course your retirement account would be, that you take your power of attorney that was done prior to 2014, you take it to your financial institution and you ask them if they're okay with it. Or you go to your estate planning attorney that created that power of attorney for you, and you ask them, does this comply with the new law that was passed in 2014?
Thank you. For that payment to the successor, which I think means for the benefit, I think the 1 to 2%, is it total assets or net assets?
Okay, that's about the trustee compensation is based upon the gross estate. So the total,
The
not
total.
necessarily the net.
Okay, and Mary Kay is saying, what role do LLCs play in estate planning?
LLC is a limited liability company. Some people use that as an estate planning tool. It has a lot of tax implications that come with it, I think. So you have to be very careful. Again, I always tell people understand what you're doing, why you're doing it, and what the consequences are. Also, you would need to make sure, or I would suggest that you make sure that that LLC has a succession plan in it, so that upon your passing, the assets of the LLC, where are they going to go? Sometimes we make sure that there's a synergy between the LLC and your revocable living trust. So if you're going to be using LLCs, make sure that they are taken into consideration as part of your estate plan, and they might dovetail with your trust.
Thank you. If we have a revocable living trust, can it be amended to provide a mini trust and provide protection for lawsuit and creditors and predators? So if they've already got it, can they amend it?
Sure. As long as it's a revocable living trust, it can be amended. It can be changed. Whether or not your estate planning attorney knows how to draft and create these little mini trusts, I don't know. So you have to talk to whoever prepared it for you and ask them, tell them what your concerns are. I'm concerned that after I'm gone, my child might get divorced. How can I amend my trust if need be to take that into account and protect them?
Okay. And then Iris is asking, what happens, if anything, if your successor trustee is also your beneficiary?
That's very common, that a successor trustee is also a beneficiary. For instance, in Bill and Mary's case, they had Susan as their successor trustee. She was also their daughter. She was a beneficiary as well. Extremely common. It shouldn't be a problem. The trustee and the beneficiary are wearing two different hats, though. So as the trustee, Susan had what we call a fiduciary responsibility, a professional responsibility to carry out the terms of the trust and do what she's supposed to do. She can't give herself more as a beneficiary. She's entitled to compensation for her time as a trustee, but she really has to follow the terms of the trust. So there's not necessarily a problem with somebody being a successor trustee and a beneficiary. It's quite common, honestly. It's just that you have to make sure whoever you're naming as that successor trustee is trustworthy, responsible, and understands their different roles and carries out their role as trustee in a responsible, professional manner.
Okay, and so second to the last question here. So the Trustee Compensation Act, can you pay a successor less than 1%?
Yes, the Trustee Compensation Act basically says, unless the trust says otherwise, here's the compensation structure. So you can say they get $50 an hour, you can say they get $5 an hour, or they get $1,000 and that's it. Yeah, you can do whatever you want inside your trust.
Okay, so the last two questions are specific to Michelle's company, so I'm going to ask you to contact her separately. But I have a question for you, Michelle, which is, let's say you're 50 and you do this, and laws are likely to be changing in the 30, 40 years before you need this to go into effect. Does it make sense to not do it that early? Is there a time period where it makes sense to do estate planning?
Yeah, personally, I think once you own a home and once you have children, you need to get an estate plan done. Even once you turn 18, you should at least have a power of attorney and a healthcare directive in place, which some might think of as part of an estate plan, but it's really super important for our young people to have those. I would say get it done whenever you feel is appropriate, but don't wait too late. And honestly, if you wait, you're only going to be paying more, right? Because the cost of doing anything is going to go up. When we create an estate plan for someone, we try to put enough contingencies in there, enough flexibility, so that if lives change, we have contingencies. So for instance, if you say, I want everything to go to my kids in equal shares, I'm going to ask you, well, what happens, God forbid, if your child dies before you? Where do you want his or her share to go? Well, what if this successor trustee can't do it? Who's going to be a backup to them? So we try to put enough contingencies in there to take into account any changes that might happen. Having said that, I think it's very reasonable to think that you would have to update your estate plan probably every 10 to 15 years, you know, because laws do change, lives change, but you could get hit by a bus tomorrow or die of COVID, you know, next month. And now you don't have a plan done just because you were worried about having to make a change 10 years from now. So I really don't think it's wise to wait. But it's also, you know, smart to understand that you need to kind of keep an eye on it. You don't buy a car and don't ever touch it again for 10 or 15 years. You have to update it, take care of it, maybe get a new car after 15 years. So it's something that might need to be adjusted. However, I've had clients come to see me, they had their trust done 20 years ago. And besides updating their power of attorney, we haven't done anything for them. Everything still reads just the way they want it. So everybody's different. Sometimes we make a lot of changes. Sometimes we don't make any changes. It just depends. A lot of times it's the family that decides they want to make changes, not necessarily the laws.
Well, thank you. That's a great closing statement. I hope everybody enjoyed the presentation. I personally found it one of the more clear presentations I've ever seen on this topic. So thank you for your very clear explanations. It was wonderful. I'm going to quickly launch an evaluation poll. So folks, if you don't mind filling that out. And Vicki, while they're filling that out, could you please tell us who won the door prize?
Yeah, sure.
Is door prizes?
I'm sorry. Iris Kurashigi and Arno Kishi.
Great. And do we have information about how to contact them?
I'm still waiting for Arnold to let me know that.
Okay, so Arnold, if you could please put your email in the chat, we'll contact you afterwards so we can find out where to send your door prize. So thank you so much. So with that, we're going to go ahead and end. I do want to remind you that next week we're talking about behavioral health care options for veterans and family members of veterans. So I hope you'll join us for that. And then the following week, we're going to hear from former POW Jessica Lynch, who was the first woman POW ever rescued. So I think it's going to be really interesting. I hope you'll join us. And again, thank you to Michelle Skelly Hobas with Sterling and Tucker. We've really enjoyed today's presentation. Mahalo.